This learning module is for educational purposes only and not to be considered as legal advice. Please consult a qualified lawyer for legal advice pertaining to the legislation. In an attempt to eliminate pitfalls to professional practice, the reading and comprehension of this learning module is a required continuing competency for renewing your 2023-24 practice permit. There will be a quiz on the content in the first step of this year's registration renewal form. The primary rationale for the requirement is due to the following ongoing experiences of the college. 1. New hires in the province practicing without being registered and potentially contravening Section 46 of the Health Professions Act. 2. Regulated members frequently failing or refusing to cooperate with an investigator appointed under the authority of the Act, routinely using the excuse, "I don't want to get involved." And 3. Regulated members routinely failing or refusing to fully comply with Sections 2.3, 3.1, and 3.3 of the Standards of Practice and Statements 2 and 7 of the Code of Ethics for the profession. The learning objectives for this video are: 1. You have to watch the video, Professional Conduct Processes, created by CRTA operations staff. 2. Identify the 5 major processes related to complaints. 3. Identify the initial actions the complaints director undertakes. 4. Describe the investigation process. 5. Describe the alternative complaint resolution processes. 6. Describe the complaint dismissal processes. 7. Identify the participants and their roles in a typical hearing. Read and comprehend the relevant sections regarding the hearings in the Health Professions Act. 9. Correctly answer the multiple choice questions contained within the online practice permit renewal form for 23-24. There are 5 major processes related to complaints. The first is the complaint is received. A complaint has to be written, it has to be signed, it has to be dated. The second is, what do we do with the complaint? Do we investigate it, or is there an alternative? We can conduct an investigation either by appointing an investigator, or the complaints director can conduct the investigation themselves. There is another stream in the legislation called ACR, or Alternative Complaint Resolution, and these gives the college mechanisms to avoid a hearing, to bring the complainant and the respondent together. The fourth is the complaint doesn't meet the tests. It is trivial or vexatious, or there's insufficient evidence, and this would allow the complaints director to dismiss the complaint. If the complaint is dismissed, the complainant can ask for a review of the dismissal through a complaint review committee. What are the initial actions taken by the complaints director? Well, you can see here, the complaints director can receive a signed complaint of a current or former member, or the complaints director can become aware of unprofessional conduct of a current or former member. He must advise the complainant of action taken regarding the complaint within 30 days. Next, he has different actions they can take. He can encourage the complainant and investigative person to communicate and resolve the complaint. He can conduct an investigation or appoint an investigator. With the consent of the complainant and the investigative person, attempt to resolve the complaint. He can make referral to an ACR, or Alternative Complaint Resolution. He can request an expert report. That is, he can go to someone who's knowledgeable and ask for them to give a written opinion. He can make a referral for incapacity assessment. sometimes behavior is a result of substance abuse or mental illness, and he can make a referral, so that person has to be assessed. He can dismiss the complaint if it's trivial, vexatious, or if there's insufficient evidence to prove the charge. If the complaint is dismissed, the complainant has notice of dismissal and the right to request a review from the hearings director. This must occur in writing within 30 days. Once a decision has been made to conduct an investigation, an investigator is appointed, or the complaints director does the investigation themselves. So the next thing done is the complaints director provides the name of the investigator to the complainant. He also supplies the name of the investigator to the investigated person, as well as reasonable particulars, which are the details about the complaint. Once the report of the investigation is completed, the complaints director decides next steps. He can refer the matter to the hearings director for a hearing if he believes there's reasonable cause. He can require further investigation if there's still questions that need to be answered. He can request an expert report if the matter needs truly expert opinion, or he can dismiss the complaint because it's trivial, vexatious, or there's insufficient evidence. If the complaint is dismissed, the complainant, the person who made the complaint, can request a review. The alternative complaint resolution, ACR, is another mechanism that can be used by the college to resolve a complaint. A referral by the complaints director with agreement from the complainant and the investigative person needs to occur for ACR to happen. A person is selected to conduct the ACR. If they believe the matter is substantially different from the original complaint, they go back to the complaints director to decide next steps. The complaints director can decide the ACR can continue, or the complaints director can commence an investigation, complete any current investigation, dismiss the complaint, or refer to a hearing. If the person conducting the ACR concludes settlement is unlikely, they go back to the complaints director, and again, the complaints director decides the next steps. They can decide the ACR can continue, or they can commence an investigation, complete a current investigation, dismiss the complaint, or refer to a hearing. If the complainant and the investigative person agree in writing to a settlement, the person who conducts the alternative complaint resolution can report settlement to the Complaint Review Committee. The Complaint Review Committee can ratify the settlement. They can amend the settlement with consent from both parties and then ratify, or they can refuse to ratify the settlement. In all cases, the complaints director must be notified, and then the complaints director can either start an investigation, complete a current investigation, dismiss the complaint, or refer to a hearing. The last process we have to look at is what happens when the complaints director dismisses a complaint. So you can see the complaint is dismissed. The complainant now has an appeal period of 30 days. They must apply in writing to the hearing director for a review of the complaint dismissal. A complaint review committee is formed. They receive written submissions from the complaints director and the complainant, and possibly the investigative person. They look at all the written submissions and they provide a written decision. They can refer the matter for a hearing. They can confirm the dismissal, or they can direct that further investigation occurs. Once the further investigation occurs, they can again refer the matter for hearing or confirm the dismissal. The second part of this presentation involves the hearing process. The learning objectives for it are: describe the hearing process pursuant to the HPA, to identify the participants at a hearing and talk about their roles, to identify the legal responsibilities and obligations related to the hearing that a registrant or a regulated member must fully comply with. Just as important is to identify the legal responsibilities and obligations related to the hearing process that the college must comply with. And finally, describe any appeal process available to the member and the college. If we look at the hearing process, the first thing we have to understand is who's at the hearing. So one of the people at the hearing is the investigative person, the person who's had the complaint made against them, and their counsel, unless self-represented. The other people who are there at the hearing are the CARTA Complaints Director and their counsel. There are tribunal members, 2 professional members, 2 public members. Any witnesses for CARTA or the investigative person, the court reporter, the hearings director, and any public who wish to attend unless the hearing's been closed. So you see, once the hearing director gets the referral to the hearing, they have 90 days to set a date for the hearing. Not that the hearing has to occur within 90 days, but they have to set a date for the hearing within 90 days. So what does that involve? They have to give the investigated person notice to attend with reasonable particulars. In other words, the details about the complaint. They have to advise the complainant about the date, time, and location of the hearing. And if there's witnesses, they have to be given a notice to attend or produce. The hearing is open to the public unless it's been closed, and we start with opening remarks by the tribunal chair. After the opening remarks, CARTA presents their evidence. This would be the prosecution. The tribunal can ask questions of either party. The investigative person presents their defense. Again, the tribunal can question any party. The defense or the prosecution can also include witnesses. There are closing remarks. The tribunal will absent itself to try and make a decision. If there's possible criminal conduct, the tribunal would order the hearings director to refer the matter to the Minister of Justice and Solicitor General. Just a couple other differences here between this type of hearing and a criminal trial. The first major difference is in the burden of proof. The tribunal is looking for a preponderance of evidence. Is a fact more likely to occur than not have occurred? The finding requires at least 51% of the evidence to favor CARTA's outcome. This is much lower than in a criminal trial where this burden of evidence or burden of proof is beyond a reasonable doubt. The other thing is the evidence. Witnesses are sworn. Witnesses can give testimony. Witnesses can be cross-examined. Questions can be asked by the tribunal, but on a much less formal basis. Once the tribunal reaches a decision, it has to write a decision. If there's unprofessional conduct, the decision will include orders and/or costs and/or fines. If there isn't, a decision still has to be written. Either party can appeal within 30 days. That is, if the decision is disagreed with by the CARTA, they can appeal the decision, or the investigative person can appeal the decision within 30 days. It's very important that the decision be reasonable. And reasonableness is the core to having decisions upheld by the courts. Just a quick review of who's who at the hearing process. The respondent, sometimes called the investigative person, is the registrative member being investigated for unprofessional conduct. They may or may not be represented by counsel. The complaints director, who is appointed by CARTA counsel, participates in the complaints and investigation process, may be represented by counsel. The hearings director, again appointed by counsel, must not participate in hearing reviews or appeals. This position does not participate in the complaints and investigation process. The tribunal members, that's the 4 people, 2 professional and 2 public. There's counsel. These are the people who represent the complaints director and the respondent. And there's a court reporter, as someone transcribes the entire hearing, will swear witnesses, and handle and mark any evidence. So what are the legal responsibilities and obligations related to the hearing process that the regulated member must fully comply with? First, they must appear. They may be compelled to testify and may be represented by counsel. May call any person as a witness, including the complainant, and give any person a notice to attend, or a notice to attend and a notice to produce any document or substance or thing related to the subject matter of the hearing. And the investigative person or their counsel may examine any witness appearing before the hearing tribunal. So what are the legal responsibilities and obligations related to the hearing process that the college must fully comply with? First, the council must appoint a hearings director and require the hearings director to not participate in a hearing review or appeal. 2, CARTA council appoint no less than 4 members to be used for both hearing tribunals and complaint review committees. 3, Section 16(1) enables the hearing director to establish a hearing tribunal and a complaint review committee that consists of 2 or more members from the appointed CARTA members and 2 members from the public. A typical panel is 4 people, 50% are public. There's still further requirements that CARTA must meet to comply with the Act. If the subject matter relates to sexual abuse or misconduct towards a patient, the hearings director must make every reasonable effort to ensure that at least 1 member of the hearing panel has the same gender identity as the patient. All members of the hearing tribunal have received training on trauma-informed practice and sexual violence. And just to be clear, gender identity is defined as a personal conception of oneself as male or female, or rarely both or neither. Additionally, Section 69 says 90 days after receiving the referral to hearing, the hearings director must set a date for the hearing, unless the complaint director dismisses the complaint, the council president grants an extension on application by the hearings director, or the complaints director and the investigative person agree to an extension. The complaints director may call any person as a witness, including the complainant, and give any person a notice to attend, or a notice to attend and a notice to produce any document or substance or thing related to the subject matter of the hearing. This is a very important slide if you're a witness at a CARTA hearing. Witnesses may be examined under oath, may give evidence on all matters relevant to the hearing, and are not excused from answering a question because the answer may tend to incriminate the witness, subject the witness to orders under this part, tend to establish the witness's liability in a civil proceeding or prosecution under this or any other enactment. But that answer may not be used or received against the witness in a civil proceeding, a prosecution under this act, or proceedings under any other act. But that answer can be used or received against the witness in proceedings in respect to perjury or giving contradictory evidence. You do not have the right to silence if you are a witness at a CARTA hearing. Your answers can't be used in a suit against you, and that answer can only be used against you if it's in respect of perjury or giving contradictory evidence. This is very different from criminal law. So what are the mechanisms available to appeal a decision? So either party, the CARTA or the member, can initiate an appeal within 30 days. The appeal must be scheduled within 90 days, or if there's conditions or suspension on the permit, within 45 days. The people who hear the appeal are CARTA counsel, and a counsel must issue a written decision within 90 days. The possible things a CARTA counsel could decide are: they could make new findings. They could quash, confirm, or substitute a hearing tribunal decision. They could refer the matter back to hearing tribunal, or they could order a rehearing by a new tribunal. The investigative person or complaints director could appeal, if they don't like those decisions, to the Alberta Court of Appeal within 30 days. The Court of Appeal would hear the appeal and issue a decision. The possibilities for that decision include: they can make any finding that should have been made by the counsel. They can quash, confirm, or substitute a counsel decision. They can refer the matter back to counsel with directions and make any award as to costs. The following materials will help you finish your continuing competency activity and correctly answer the multiple choice questions. There are note pages for this PowerPoint presentation in PDF format. There's learning materials for the continuing competency activity. There is a link to the Health Professions Act and a link to the Respiratory Therapist Professional Regulation. Click on each of them to get to the proper area. Thanks for taking the time to watch this.